And I'm calling it now. My prediction is in. Keemstar is going to succeed on this motion.
You know, for a Montreal attorney talking at you from his car, I'm actually doing quite well on my prediction of American lawsuits. Viva Fry, Montreal litigator turned YouTuber, and today, as promised, is not another Michael Flynn vlog. I am Michael Flynn out until a decision comes down from the DC Court of Appeal. Today we are circling back to a lawsuit on which I have done several vlogs in the past, that being the Nico Romeo Lacoste lawsuit against Daniel Keemstar Keemstar, you know what I'm talking about. And you know what, if you don't know what I'm talking about, a 30,000 foot overview with the requisite hyperlinks in the corner here as I do it, but not right now just yet. Nico Romeo Lacoste is a world famous tattoo artist, and according to his website, he describes himself as follows. Based in Los Angeles, Romeo Lacoste is a world famous tattoo artist with an equally prestigious clientele. He currently leads a team of world-class artists at the California Dream Tattoo Shop, which he owns and operates. And according to his website, his clientele consists of, or at the very least consisted of, the following celebrities in particular: Kendrick Lamar, Justin Bieber, Ariana Grande, Ray Shremmerd, YG, Rich the Kid, Juice WRLD, The 1975, James Charles, Jeffree Star, Dolan Twins, All Time Low. Nico Romeo Lacoste found himself on the receiving end of accusations of improper conduct with people who are under the age of 18 as relates to text messages and potentially videos and pictures sent from his mobile phone. Because of the drama of the situation, Nico Romeo Lacoste ended up on Daniel Keemstar Keem's show called Drama Alert, and for those of you who don't know, Daniel Keemstar Keem has a show on YouTube called Drama Alert where he goes over all of the drama of the internet. Keemstar dedicated a considerable amount of coverage to the issue, including interviewing one of the alleged victims, and in his coverage referred to Nico Romeo Lacoste as the dreaded P word that rhymes with potatophile. As a result of Keemstar's coverage of the drama, Nico Romeo Lacoste actually filed a lawsuit against Keemstar on the basis of tortious interference with contractual relations and interference with prospective economic advantage. Nico Romeo Lacoste even sought injunctive relief against Keemstar. Now, I did a vlog breaking down that lawsuit. I'll link it right here. Give it a watch if you haven't seen it, but I did not have high hopes for that lawsuit for one particularly good reason. It made a judicial admission of the material accusation against Nico Romeo Lacoste. I kid you not, Nico Romeo Lacoste, through his counsel, made an admission in the lawsuit that the individuals in question were in fact minors or underage, but that Nico Romeo Lacoste didn't know. Now, in response to Nico Romeo Lacoste's lawsuit, Daniel Keemstar Keem filed a motion to dismiss under California's anti-SLAPP legislation. And for those of you who may not know what SLAPP legislation is, SLAPP is a strategic lawsuit against public participation, and certain jurisdictions have anti-SLAPP legislation, meaning you can seek to dismiss a lawsuit that is itself a SLAPP suit. So Keemstar filed a motion to dismiss Nico Romeo Lacoste's lawsuit on the basis that his lawsuit was in fact a SLAPP suit and ought to be dismissed under California's anti-SLAPP legislation, and I did a vlog breaking that down as well. If you haven't seen it, I'm gonna link it right here. Give it a watch as well. Now, admittedly, it was a very easy prediction to make, but I did make the prediction that Keemstar was in fact going to succeed on his anti-SLAPP motion to dismiss, and he did in fact get Nico Romeo Lacoste's case dismissed with prejudice. United States District Court, Central District of California, Western Division. Nico Romeo Lacoste, doing business as the California Dream Tattoo plaintiff versus Daniel Keemstar Keem, doing business as Drama Alert defendant. Judgment in favor of defendant Daniel Keemstar Keem. Having considered defendant's motion to strike complaint pursuant to California Code of Civil Procedure section 425.16 and the papers filed in support thereof, and the court having granted defendant's motion in its entirety for the reasons set forth in its order entered June 23, 2020, it is hereby ordered and adjudged that 1. Plaintiff Nico Romeo Lacoste takes nothing in his action, that the above captioned case be dismissed with prejudice, and that judgment hereby is entered in defendant's favor as to each of plaintiff's causes of action. 2. Defendant is the prevailing party in this action. 3. Requests for attorney's fees may be made by a regularly noticed motion to the court, and 4. Requests for costs may be made by application to the clerk of the court. This document constitutes a judgment and a separate document for the purposes of Federal Rules of Civil Procedure 58A, dated July 13th, 2020. Dismissed with prejudice, meaning that Nico Romeo Lacoste cannot even amend his claim to remedy whatever deficiencies there were in it, nor can he file on the same basis ever again. Now, from what I understand, he is appealing the decision, but it has nonetheless been dismissed with prejudice. Dismissed with prejudice, and Keemstar can file a claim for attorney's fees, which he did, claiming over $151,000 in legal fees. Now, just to go over the procedural background very quickly, because we've already gone over the factual background. Notice of motion and motion for attorney's fees following issuance of order granting anti-SLAPP motion. On March 10, 2020, plaintiff filed a complaint against Mr. Keem for 1. 1. Interference with prospective economic advantage, and 2. Interference with contractual relations. On May 1, 2020, defendant filed a motion to strike the complaint pursuant to California's anti-SLAPP statute. On June 23, 2020, the court issued an order granting Mr. Keem's motion in its entirety. The court also held that plaintiff failed to show a minimal probability of prevailing on his claim because the First Amendment bars the causes of action. On July 13, 2020, the court entered a judgment in Mr. Keem's favor, dismissing plaintiff's complaint with prejudice and holding that Mr. Keem was the prevailing party. Attorney's fees may be made by a regularly noticed motion, and requests for costs may be made by application to the clerk of the court. And then we get into the substance of the law, which is pretty straightforward in this case for reasons we're about to see. Mr. Keem is entitled to a mandatory award of attorney's fees because he prevailed on his anti-SLAPP motion. Quote, a prevailing defendant on a special motion to strike shall be entitled to recover his or her attorney's fees and costs, end quote. And then citing the jurisprudence of Ketchum versus Moses, quote, any SLAPP defendant who brings a successful motion to strike is entitled to mandatory attorney fees, end quote. Now, in law, when interpreting legislation, there is a legal distinction between the term shall and may when it comes to the court's powers. When the court may do something, it is discretionary. When the court shall do something, it is not discretionary, it is mandatory. And it seems that under the applicable legislation, there is a mandatory fee shifting such that the losing party is required to pay the prevailing party's legal fees when they succeed on an anti-SLAPP motion to dismiss. No discretion of the court, the losing party shall pay the prevailing party's legal fees. Does that mean it is carte blanche to be required to pay whatever the prevailing party is claiming in terms of legal fees? Well, we suspect the answer to that is going to be no, and I suspect that is going to be Nico Romeo Lacoste's defense to this application, but meanwhile, Keemstar is claiming $151,000 in legal fees. Obviously, the amount claimed has to be reasonable, and we will get there, but first, a little more law. The fee recovery provision set forth in section 425.16c was intended, quote, to discourage such strategic lawsuits against public participation by imposing the litigation costs on the party seeking to chill the valid exercise of the constitutional rights of freedom of speech and petition for the redress of grievances, end quote. In examining a fee request, the anti-SLAPP statute must be, quote, broadly construed so as to effectuate the legislature purpose of reimbursing the prevailing defendant for expenses incurred in extricating herself from a baseless lawsuit. Graham suit versus Klanos, typo included. The purpose of a fee shifting is subverted if a defendant is not fully compensated when his SLAPP motion is successful. And I'm sure you can imagine that there is going to be a difference between compensation and a windfall, but first we have to address the fact that the legal fees claimed have to be reasonable. The amount of attorney's fees sought is reasonable. The starting point for a district court's assessment of fees is the Lodestar calculations.
Lone Star!
i.e. the multiplication of counsel's reasonable hourly rates by the number of reasonable hours counsel worked. To determine the reasonable hourly rate, courts are to look at the rates customarily charged for work of the type performed in the relevant legal community, the reputation and experience of the attorneys who performed the services, the quality of counsel's services on behalf of their client, the complexity of the work performed, and the results achieved, end quote. Now recall in the Aquila Obviously versus Sargon of Akkad lawsuit, Sargon of Akkad was awarded his legal fees in the amount of $38,000 for what I believe to be was a procedurally and legally more complex case. Now wait until you get a load of the hourly rate of the attorneys in this file. Mr. Keem bases his fee request on the following hourly rates. Attorney paralegal, Eric M. George, partner, hourly rate $900. Kim S. Zeldin, partner, hourly rate $600. Eric A. Westland, associate, hourly rate $450. Ann Kim, paralegal, hourly rate $150. And this is United States dollars. In Canadian dollars, this is like $10,000 an hour. All right, I am joking a little bit. These hourly rates are actually industry standard. It is sickening, but they are actually industry standard. These rates are well within the rate of rates generally recognized as reasonable in the relevant community in which this court sits, here in the Los Angeles area. And I say this again, jokes aside, he is right. It is obscene how much lawyers charge, especially partners, but this is not obscene as an hourly rate as far as lawyers go. I mean, it may be obscene, and I can certainly understand how a lot of people will consider it to be obscene, but the industry is just obscene. The hours claimed are reasonable. In awarding attorney's fees to the prevailing party in an anti-SLAPP action, the Ninth Circuit recognizes that, quote, by and large, the court should defer to the winning lawyer's professional judgment as to how much time he was required to spend on the case. After all, he won and might not have had he been more of a slacker. Grant versus Eisenhoff. Here, Mr. Keem is seeking an award for 269.6 hours of attorney time and 38.2 hours of paralegal time. Over 300 hours to prepare and file and succeed on an anti-SLAPP motion to dismiss. I'm not saying that's excessive, I am just predicting the court is going to bring down that amount somewhat. And then we get into the question of costs, which abides by the same principle and is for an amount of $8,000 and change, so let's just go over that really quickly. Mr. Keem is seeking $8,188.60 incurred by his attorneys for online research. Such online research costs are recoverable. Thus, the court should issue an order reimbursing Mr. Keem for these costs. Conclusion. For the foregoing reasons, Keem respectfully requests the court award him $151,600 $2,785 in attorney's fees and $8,188.60 in costs, plus any fees and costs submitted in connection with the reply brief. And Nico Romeo Lacoste's opposition to the demand for legal fees is obvious. He is obviously going to claim that the request is excessive, obviously. Plaintiff Nico Lacoste's opposition to motion for attorney's fees and costs. Defendant's request for nearly $160,000 in attorney's fees and costs in this case is unreasonable, and this court should deny it. While an attorney fee award to a defendant prevailing on a special motion to strike as strategic lawsuit against public participation (SLAPP) is usually mandatory, ascertaining the amount of reasonable attorney's fees awarded to a defendant is left to the trial court's sound discretion. Inflated fee requests constitute a special circumstance supporting an attorney fee award for less than all of the hours reasonably spent to a defendant prevailing on a special motion to strike as strategic lawsuit against public participation (SLAPP). A trial court, quote, assessing attorney's fees begins with the touchstone or lodestar figure
Lone Star.
based on the careful compilation of the time spent and reasonable hourly compensation of each attorney involved in the presentation of the case. Because the legislature specified the prevailing defendant, quote, shall be entitled to recover his or her attorney's fees and costs, an award is usually mandatory. The legislature, however, did not intend recovery of fees and costs as a windfall. Inflated fee requests constitute a special circumstance. In emphasizing that a trial court retains the discretion to award attorney's fees in an amount that is less than the lodestar amount, the Ketchum court noted, quote, to the extent a trial court is concerned that a particular award is excessive, it has broad discretion to adjust the fee downward or deny an unreasonable fee altogether. Now, yet again, I don't know who Nico Romeo Lacoste is pleading for at this moment. It seems he's making all of the judicial admissions for the best case of Keemstar to recover his legal fees. He is citing the same case law as Keemstar, and his best argument is that the amount should be reduced somewhat because there is a snowball's chance in summer that the amount is going to be written off entirely because it is excessive. Nico Romeo Lacoste makes the argument that the amount should be reduced because if you look at the bills closely, there is in fact some double billing, which is
highly uncommon in the industry.
Thus, out of the total of 307.8 hours expended by the attorneys and paralegals who allegedly worked on the matter, attorney Kim Zeldin is said to have clocked 148.7 hours at $600, while attorney Eric Westland clocked 115.5 hours at $450. Much of the effort expended by Mr. Westland was duplicative of the effort expended by Ms. Zeldin. Thus, example, the billing statement shows that on May 1, 2020, the following entries were made. Clearly, only one attorney should have been, quote, finalizing, end quote, the motion to strike prior to filing with the court. Instead, we have Mr. Westland requesting 11 hours of attorney time at $450 per hour and Ms. Zeldin requesting 6.5 hours of attorney time at $600 per hour for performing the same function. And there are more allegations of double billing, and I'm not thoroughly convinced about the arguments because sometimes it does in fact take two lawyers working on something to finalize it, but all that I have to say is that $151,000 for what was done in this file, in my humble opinion, ought to be reduced somewhat. But Nico Romeo Lacoste, going big before he goes home, is saying that it is so unreasonable, in fact, that the amount should be denied altogether. Under certain circumstances, a party's acts may justify a denial of attorney's fees altogether. As the California Supreme Court explained, quote, if the court were required to award a reasonable fee when an outrageously unreasonable one has been asked for, claimants would be encouraged to make unreasonable demands, knowing that the only unfavorable consequence of such misconduct would be the reduction of their fee to what they should have asked for in the first place. To discourage such greed, a severe reaction is needful. It is difficult to imagine a more unreasonable fee request than the one brought here. In this case, defendants seek an unreasonable recovery that is grossly inflated by, among other things, 1. The needless and excessive use of multiple lawyers working on the same issues and billing for editing the other's work, particularly given that lead defense counsel Eric George has a vast experience in litigating the California anti-SLAPP statute. Well, if he has a vast experience litigating the anti-SLAPP statute, chances are he also knows what is reasonable to claim, so that might not be the best argument yet again. For all the reasons set forth here and above, plaintiffs pray that the court deny the defendant's motion for attorney's fees in its entirety. It is a well-presented argument, but I do not think it is going to succeed because it would basically allow Nico Romeo Lacoste to get off scot-free for having filed the frivolous lawsuit in the first place. My prediction is that Keemstar will be awarded legal fees, but the amount will be reduced, I suspect, to about $50,000, which, although excessive, is entirely reasonable under the circumstances. And oh my goodness, I almost forgot the most important thing. Hold on. You have been asking, this is Harry the guinea pig, the newest addition to our family.
Yeah, look at him. Say hi, Harry.
Alright, and with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm.
What does that mean?
If you want to support the channel, all of the support links are in the pinned comment. We've got PayPal, Subscribestar, Patreon. Check out the podcast that I do with Robert Barnes. It's on iTunes, Podbeam. It is called Viva and Barnes, Law for the People.
Daddy,
Yes.
he's doing peace out.
And now you know your vlog. Peace out.
Peace out.